016871 SEA. Council, will you make your appearances for the record in this order? AAG, Mothers Council, CASA.
Patricia Bauer for the department.
Grania Griffiths for Mother Fadimo Ali.
Elizabeth Barris covering for April Rivera, attorney of record. CASA is Fred Fitzner. He is not present, but I can proceed.
All right. And so why don't I hear from you, Ms. Griffiths? At the call of the calendar, there was some indication that you have an issue regarding service that you would like to address. I had understood that it had to do with whether service on an attorney is adequate service, and I had seen a return of service that indicated that Ms. Ciuta on June 21st, 2024 had personally served it on Ms. Ali herself. But why don't I hear from you about what your issue is?
Yes, thank you, Your Honor. And to be clear, my issue is about service of the motion to default. Civil Rule 55 says that a party who has appeared shall be served a motion to default. And while it is true that generally attorneys are authorized to accept service on behalf of their clients, I think I need to be clear that I have not received authorization from Ms. Ali to accept service of specifically a motion for default. And
I don't think you have to be authorized.
If I may, Your Honor, if I may just
Go
continue.
ahead.
Per Ha versus Signal Electric, that's 182 Washington App 436. Attorneys need express authority from clients to authorize service, and that's necessary to protect clients from serious consequences arising from misunderstanding between clients and attorneys. And additionally, Ashcroft v. Powers, that's 22nd Washington 440 at 443, states that judgment of service entered upon acceptance of service that an attorney doesn't have authorization to do will be overturned. And I think, Your Honor, the reason that I am making this objection today is because I don't have authorization to accept service. I am here representing Ms. Ali on her behalf. So if my presence, if I am sufficient to accept service on her behalf, then my presence here representing her, ready to set for trial, should also be sufficient. I don't see how it could be that she could not have to be served herself, but yet she needs to be here to set for trial. Either I can do both of those things, or I can do neither of those things. Additionally, as soon as I received the motion for default, I did file a motion to withdraw, and I won't go into the details for that, but I think perhaps it is clear why I needed to do that based on the timing, based on receiving the motion for default. So I am asking, Your Honor, that the motion not be granted. If the motion is going to go ahead, I am objecting and would ask that it be continued until after I am permitted to withdraw, should I be permitted to withdraw. And Ms. Reddy, I do have direction that I'm able to act on today that Ms. Ali is ready to set this case for trial. Thank you.
All right. I will indicate my understanding of these issues, and then we'll hear argument from Ms. Bauer and Ms. Barris. It is accurate that where original service is required for, such as for a notice and for a summons and petition, or for an order to show cause, or a motion for contempt, that service on an attorney is insufficient. However, once personal service, original service has been achieved, other motions in a case and an attorney has appeared, other motions in a case do not require further personal service. Service on an attorney is acceptable. I think while I, in a sense, understand your reasoning, Ms. Griffiths, about if it's good enough to give you net motion, for default, your being here should be, if service of the motion for default may be made on you, then you should be able to appear and request that the case be set for trial. But the issue I have before me is a motion for default. And in order to prevent a default, what I need is not an appearance. I need an answer. And there is not an answer. And therefore, I believe that having been given notice of the motion for default and with there not being an answer, that it would be appropriate to find your client in default, after which time, once your client is in default, it is appropriate for the department to be able to take testimony. Before I circle back to Ms. Griffiths, Ms. Bauer, Ms. Barris, do either of you want to be, to further make a record or to be heard on those issues?
Your Honor, the department agrees with the court's position, and we specifically filed the motion for default in order to compel the mother to appear here today. As you've recently heard in the siblings trial, we've been trying to get the mother's attention since March of 2023, and I didn't want to be in the same situation with this sibling. So there is no answer filed. So I would either ask to take testimony today or preserve the default and set testimony over to after Ms. Griffith's motion to withdraw is addressed.
All right, Ms. Barris.
Thank you. I'm in agreement with the court's analysis regarding the service issue, and I am okay with either plan laid out by the state in terms of setting it. Well, I'll just say that. Thank you.
All right. And it sounds like your preference, Ms. Griffiths, I'll hear from you in further reply, but my assumption is that if I were to grant the motion for default, you would prefer that the testimony be deferred until your motion for withdrawal is also heard on the 13th.
Yes, Your Honor, that would be my request. And I know it's a bit unusual, but I did note that motion in this court, anticipating perhaps that might happen. So that would be my request.
All right. At the end of the day, you'll end up having Judge McCoy for that testimony anyway, because she will be here on the 13th unless she sends it to an overflow court. I am granting the motion for default. I do find that there was proper service of what was required to be served on the mother. There was personal service, and that service of the motion for default was properly made on counsel of record. And that's what's required when there's a notice, when there's an appearance. Notice is required to either the party if they're unrepresented or to the attorney if they're represented. So I find that both of those notices were proper. I am entering an order for default and going to preserve. I mean, to be clear, should Ms. Ali appear and move to set aside that default, given the standards about default, I'm confident that will happen, that would be granted. But for today, she is in default, and the order should reflect that testimony will be taken on the 13th. Should she not appear?
Thank you, Your Honor.
Thank you.
All right. I think the remaining testimony matter we have is Beauchamp. Is that correct?
Yes, Your Honor, with Beauchamp.
I think what I'm inclined to do is send that over to Judge McCoy now, but let me hear from the parties on that, which other matters they still have on the calendar.
Your Honor, Beauchamp is with assigned attorney Jennie Cowan, who is with Judge Richardson. I am going to check in with her now via messaging if I can hop in or not. I do not know the answer.
Okay. All right.
And Your Honor, there's also the motion to withdraw by Father's Counsel, Mr. Kim.
All right, let's go ahead and address. Oh, that's also Ms. Cowan.
Yes, that's,
So as soon as we've heard back from Ms. Cowan, perhaps Ms. Barris, you can get direction on the motion to withdraw. And one thing I would note, well, I'll wait till we get on the record before I note that. All right, calendar number 37 and hearing number 17, Henry Nevaeh Willie, cause number 237006699 SEA. Oh, they're ready for trial. They don't need to go on the record. That will be a pass. Thank you. Moving on to calendar number about 38 and hearing number 18, Yater. Do we have an update on whether that is going on the record?
So Ms. Gold, oh, there she is. I'm not sure if she's done with her breakout room. There she is.
It looks like she is. All right.
I'm not actually, Your Honor. I am trying to get the client in there. I'm not sure the notice is going through to her or through them. So I'm working on that. McSaylor, are you on here? Could you please accept the breakout room invite? I may need a little more time. I apologize.
That's okay. Let's see if we can figure this out for you. See if Ms. Taylor can hear me. Ms. Taylor, can you let me know if you can hear me? If you're on the phone, press *6, please.
And, Your Honor, I don't know if it's just me. I'm hearing the word Taylor, but the parents.
It's Ms. Saylor. That's right.
Sorry.
Thank you. Ms. Saylor, are you on the line? Would you unmute and let us know? I do see that we have Abigail Ash Saylor. We have Mick Saylor on the line.
I can continue to try to reach them separately, but I was hoping this might be easier. It appears not to be.
Okay.
I did try chat earlier.
All right, and apparently Mick Saylor didn't respond to a chat either. All right, I will circle back, Ms. Gold, but we are approaching the end of the cases we need to hear on the record. So I'm going to next move to calendar number 40 and hearing number 19, Henry Lexand Joy, Isaiah Sanow, and Aragorn Sanow. Cause numbers 237-021345, 021329, and 021337 SEA. Counsel, will you make your appearances for the record in this order? AAG, Mother's Council, CASA.
Jessica Puckett for the department. Ms. Boldwan.
And Father's Council as well. Thank you. Go ahead. Sorry, Ms. Puckett, go ahead.
Jessica Puckett for the department, and Ms. Boldwan, the assigned social worker, is present.
Seth Koenig for Mother, filling in for Felicia Warnick.
Hannah Gold for Ragnar Bloom. We were just assigned the father, Mr. Sanow.
Elizabeth Barris for CASA for Chelly. She's not present, but I can proceed.
All right, and so I had set this for a status conference, realizing, Ms. Gould, that whoever was appointed would have just been appointed. And so it may be that what I'll hear is that we need to continue this, but this is a hard set 13-day trial on October 7th. And as you are probably aware, there is a motion for change of counsel. I ultimately did not hear that and had Judge Wilson hear more from Mr. Sanow and Ms. Floria in camera. So I don't know anything more than any of the rest of you know about that, but I do understand that the motion was granted. We now have new counsel, Mr. Bloom and Ms. Gold. And I just didn't want, given the trial date and the length of trial and how much of all of our time that is probably taking, I wanted to check in sooner rather than later. So Ms. Puckett, I'll hear from you and Ms. Gold about where things are.
So I know that the court shares the department's concerns because of the hearing that was before Your Honor, before it went to Judge Wilson about delaying in the children's permanency. And I know that the trial was set like 6 months before the trial date. So I'm not going to belabor those points. I want to emphasize a few things. One, I heard earlier, Your Honor, say that you're not going to be here on September 13th. That's when our next status conference is. And I want Your Honor to be the judicial officer setting our hard set trial date. I don't know who's going to be here on the 13th. It's not that I don't have confidence. It's that I know that this court understands the case, how long it was hard set, that change in counsel came really late, and that it's going to result in a delay in permanency.
So
I'm
just going to interrupt you for a moment. I'm inclined to because it's a hard set trial before me, I am inclined to special set it. And I'm just away the morning of the 13th. So for example, I could set it on the 12th at 8:30. I agree with you. I think there are a lot of reasons why I should be the person to hear this issue.
Okay, well, there are other dates in September that I couldn't do a status conference, but if we can special set it the morning of the 13th or that week, really.
No. The morning of the 12th is what I said.
Oh, the morning of the 12th works for me too. I'm sorry. So, and then I guess the only other thing that I wanted to mention to the court, but we can really address this on the 12th. You know, I don't want the court to fill up its calendar with other hard sets and this matter not be able to be set before you, either if you rotate or whatever. So I don't want that to happen, but I am going to rearrange the leave that is on the trial board around what works for this court in terms of hard setting, unless I have planned out of state leave. And so if the court, you know, I want all the parties to know, but I also just want to state on the record, I want the court to email me if there are dates that you want me to check that currently show me unavailable on the trial board, because if I'm not out of state, I'll modify them. And I think my only remaining hard set for this year is trip. So that's the only thing that I'll have that's really limiting, other than some September leave. And other than that, I'll just ask the court to set us for the morning of the 12th and to hold the court's calendar as much as possible. I know Mr. Bloom doesn't have any trial unavailability, so I'm hoping that helps the court find dates for us.
All right. Does the morning of the 12th work for everyone else at 8:30?
If I will have coverage, but that's fine. Yes.
I am out that week, which is fine, but Mr. Bloom has 72s on Thursdays, and I think as the court is well aware, Thursdays are pretty hectic here. So I would be just concerned about creating delay for the other courtroom if we set it on the 12th.
All right, let's see if there's another date.
Could we do one on the 13th?
From what I can see on his calendar, he's free.
Works for coffee.
We have a meeting that goes till.
Let me take a look at what that is.
Actually, I think I'm going to ask, is there any way we could do it the following week? Just since I only have access to Mr. Bloom's sort of generic skeleton calendar and I am out that week, I want to make sure either Mr. Bloom or I can be here for this.
I can't do it the following week. I'm out of state for part of that week, and then I'm out on the 20th. And I'm out on the 6th, but I could do, I could do the 9th through the 12th any other time. I don't know if that was a time you said he was out.
What about the 11th at 8:30? For some reason, we're showing our trial starting at 8:30, but I may just rob that time. So what about the 11th at 8:30? Could people do that? I know Ms. Gold would like more time, but the problem is that because of Ms. Puckett's unavailability, that just kind of pushes us too far down the road.
I don't see anything on Mr. Bloom's calendar that prevent that from working. I will state that we have literally nothing on this case, including, it sounds like, over 30 volumes of discovery, if not more. So if the court and the department would like us to set for trial on that date, they need to get us the proper information. And it sounds like there may have been an email that sent discovery, but I just wanted to make a record of that.
I'm not sure. We sent all discovery yesterday to NDD. So it's
Okay.
46 volumes. And I've
How
communicated
many?
it's gold.
How many?
It's 46. It was recently updated.
Okay. I guess what I'm hearing is that realistically, although some people are not happy about this, it really can't go to trial with new counsel on October 7th. And so I'm going to release those dates for all of us from the calendar. I guess basically strike the trial date, but then set our new status conference. And I guess I'll hear from you, Ms. Puckett. I do think, why don't we check in on September 11th at 8:30 with the hope to, I really recognize that Mr. Bloom and Ms. Gold are just sort of newly getting on this. I recognize that they may need to ask for further continuance. Ms. Puckett, if that's when you're on leave and you'd like to just be able to move that in advance, you should let folks know. The other alternative is we could pick something the week of September 23rd. But of course, the further down the line we get, the harder it will be to find a date. I will just let you know that as of now, and I don't think I necessarily have to be the person to try this case. We just need someone with a big block of time. And I will look at both. Has anyone been disqualified from this case? Any of the dependency judges that you're aware of?
Yes. I believe in Miss Barris, the problem is everyone has changed counsel. I've been on it a while now, but this was before my time. But I believe that Judge Nelson, or Judge Lee, Nelson Lee, may have been disqualified.
Well, he's not in this department anymore, so that doesn't matter. But has Judge McCoy, Judge Richardson, or Judge Chung been disqualified to anyone's knowledge?
No. And the only officer it was ever set for trial in front of where there was a DQ deadline was Your Honor.
Okay. All right. Look, sitting here right now, but many things move. My calendar is pretty full through the end of until the week after Christmas, and then the first couple weeks in January. But that doesn't mean we can't figure something else out with a different judge or possibly shifting some things around. So my hope will be to have, one of the challenges with this case is that it's a 13-day trial. So I'm going to ask that everyone consider whether their time can in any way be reduced. And then we will check in on the 11th. Do we want to set a second date right now for if the 11th doesn't work out?
Well, I think we should do two things. We should set for the 11th and probably strike the 13th.
Yes.
Just because it's so close in time. And my request is going to be, I recognize people won't know a lot by the 11th, but I do think that, dependency cases, even this dependency case, which is a challenging case, that counsel can estimate, how long they're going to need to get through 46 volumes of discovery based on their training and experience, like based on their prior experience in dependency cases, so that on the 11th, we should be able to pick a trial date that is reasonable for a competent attorney to have reviewed 46 volumes of discovery and be prepared for trial. I'm not opposed to setting a second status, but the first Friday I would have would be the 27th. And so I just don't want to wait that long, to get to the point where we're looking at trial dates. All
right. Well, I'm sure there will be other statuses no matter what, but let's plan to convene at 8:30 on the 11th. To the extent people are in a position to revisit whether there's anything about their trial length estimate that has changed. And then I think what would be helpful, Ms. Puckett, is to do kind of a calendar of unavailability, sort of similar to the one, I got one from, I forget who sent it to me in Smith, but that was super helpful to have that, what amounted to a calendar explaining what days were unavailable and why. So you might check in with, I think that was Ms. Farner who had done that calendar. She might be able to get that to you. And I really am going to want the calendar to go through probably at least January.
And Your Honor, for Felicia Wartnick, she is our AOD on the 11th, and she also has 6 hearings currently set. It's possible she could do all of that, but that might create issues.
That
Well,
does sound like it.
I sort of feel like, and I don't know, I'm obviously the court can disagree with me and everybody else can too, but I feel like for Ms. Wartnick, what we need is her updated unavailability. For it's Father's Council where we need them, you know, to come, or for the court to decide, here's the amount of time that 46 volumes of discovery should take someone to be ready for trial if we hard set.
Already
I think
clarify, we truly know nothing about this case.
No,
Did the mother already agree to dependency?
No.
It's very contested.
It's a
Okay, term, I'm sorry, sorry, term. See, this is literally.
Right,
what
and,
we
and
know.
I do think at one point Ms. Puckett was talking about a dependency, and
Okay.
it's a termination as to all these 3 children, is that right?
That's correct, and I'm sorry if I misspoke.
Wasn't there a dependency as to a 4th trial that was
There was
running
a-
along with this? Has that been resolved?
That was resolved by agreement. That was hard set before Your Honor for January of this year, and we resolved it in December.
Okay. All right, thank you. So Mr. Conant, do you think there could be coverage for Ms. Wartnick? I tend to agree that I'm not sure, given that she was supposedly ready to go to trial on October 7th and has the same client and the same discovery, that other than having a good sense of her availability, I'm not sure that her actual presence as required.
I'm guessing there could be coverage. It's likely we're going to have multiple attorneys in trial that week. So coverage will be slim, but if it's just an issue of her availability, I think that the court has that already. So I'm not.
Well, I'm going to be asking for there to be, I think I have it, and I think Ms. Wartnick is usually pretty good about updating her availability, but I'm going to ask that the day before the 11th, we have updated, very detailed availability, just because so many pieces are moving in terms of hard set trials. I think I am just going to go ahead and set it then, because there isn't another time I can set it. And hopefully we can have coverage, and if really we reach a situation where it's impossible to go forward, then I will likely move it to the 27th. Although Ms. Puckett, you're gone the whole week of the 16th. Are you gone the most of the week of the 23rd or not?
I was scheduled to be. You know, I'll let the court know, like, if we really can't do anything on the 11th, I might need the court to accommodate appointments, but I could appear on the 20th.
Okay. Well, why don't we see what we can do on the 11th? If it turns out that we can't do that, we'll check in and see what our next available date is. In the meantime, I will be looking. I will hopefully have the availability on the 11th, and we'll be looking hard at what trial dates before which judge might be available. All right. Yes.
I was just ordered that number 34 needs to go on the record. Ms. Johnson has made a request.
All right. We will, so that will conclude this matter, the Sawnow matter. I will go on the record on calendar number, I'm sorry, 34?
Yes.
All right,
Babies too.
sure, got it. Calendar number 34, Inri Baby Tutor, cause number 24701249 SEA. Going to have counsel make their appearances for the record in this order, and then have your clients introduce themselves afterwards. AAG, Mother's Council, Father's Council.
We have an AAG.
Is Ms. Clifton still doing testimony in another matter?
I don't believe so, but maybe parties.
I'm not sure. She's definitely on the emails alerting that the case needs to go on the record.
I can message her right now, Your Honor.
Okay. Why don't we go ahead in the meantime and take the Yater matter? Calendar number 38 and hearing number 18, Inri Raleigh Yater, cause number 2470139995 SEA. Counsel, will you make your appearances for the record and have your clients introduce themselves if you wish? In this order, AAG, Mother's Council, Father's Council.
Alex Campbell on behalf of the department.
Jill Cagle, DCYF Supervisor.
Ms. Gold.
Yeah, Hannah Gold on behalf of Ragnar Bloom, who represents the father, McSaylor, who appears to be on the Zoom but has not responded to previous interactions, but has been on since I believe the beginning of the calendar.
McSaylor, if you are still on and can unmute yourself, please do so and introduce yourself. If you're on the phone, you would press *6. But at least earlier, there was a tile indicating McSaylor was on Zoom. I don't think I'm seeing that anymore.
It is still on, Your Honor.
Okay,
It's under Abigail Ashseaman.
got it. All right, go ahead. We'll have Ms. Culpa make her appearance.
Tracy Culpa on behalf of Rose Yater.
Where are you seeing it at the top? Maybe
It's under the A's, so down below the active participants.
I see. Actually, I still don't see, but there I see. All right, thank you. All right, so we are here for a pretrial conference and fact-finding hearing. Ms. Campbell, I will start by hearing from you, and then I'll hear from Ms. Gold.
Thank you, Your Honor. So earlier this morning, I was able to send up an agreed dependency order for parent 2, Rose Yater. So that portion has been resolved. I know the court has seen a series of continuance requests in this case. But at this point, Ms. Gold and I have worked in between her hearings this morning to reach what should be a resolution of this case. And as the court can see, I'm not sure that McSaylor has been responding on Zoom, so I think I'll let Ms. Gold speak for herself as to what she thinks the most appropriate course of action is at this point.
And what are you, do you want Ms. Gold to speak to this, or are you requesting another short continuance to address McSaylor's?
So I am not specifically requesting the continuance. I have my client on as to whether or not they can approve of a short continuance. But I, as an officer of the court, cannot be setting this case for trial today when we are this close to an agreed order.
All right. Ms. Gold, why don't I hear from you?
Thank you, Your Honor. What Ms. Campbell said was accurate. We, I think, negotiated everything down, truly down to the final word here. I am just trying to reach the client for approval and appear to be having some technical difficulties on that. And so I would ask, ideally for 2 weeks, but 1 week or even a few days, although I'm not sure about the reliability of like the phone situation with our client, but the department may be able to speak more clearly to that. But just a few days to hopefully get an approval from the client. My understanding is it is mostly approved, if not 99.9% approved. I just need signatures. And I was hoping to just do a colloquy today if they were present, just to make it simple.
All
But
right.
I can't do that now.
Why don't we, I think what I'm inclined to do, but I'll hear if anyone objects to this plan, is to continue just for 1 week. I think that's, if everyone's available, I think that's going to be a much more manageable calendar. Just given sort of what I'm seeing about, well, I don't know. I could be wrong. They're both big. All right.
And Your Honor, if it makes no difference which calendar it's on, I would ask to not have it on the 6th. I'd ask to go on the 13th.
All right, Ms. Gould, do you object? It sounded like you wanted an extra week if possible.
It's just easier to have a little extra time, but I don't expect that we will need to go on the calendar, but I think the 13th would be great if we could just have a little extra time in case there's technical difficulties.
All right. Why don't we go ahead and put it on the 13th? We'll set it, it doesn't sound like we'll be setting it for trial, but should there not be an agreement from Nick Saylor at that point, that's likely what will need to happen. But the mother's order has already been submitted, correct?
Parent,
I'm sorry,
parent two went
parent
up this
two.
morning.
All right. That's right. I'm sorry. Parent 2 has entered an order, and it's parent 1 that we're continuing to the 13th. Great. That will conclude this matter. Thank you. I have going to turn now to the Mejia matter. Calendar number 20. Aimee Isabella Mejia, cause number 21700583.
I'm sorry to interrupt, Your Honor. The Jennie Cowan is covering that for Debra Rivera. Ms. Cowan, I think, is almost done next door. My last update from her, but there's been a lot going on and I am not able to cover it.
And Ms. Clifton return.
All right. And would you remind me what we still have?
I was gonna say it, you can remember.
I think it is no, it's not Bisham. That just.
It was the one where Kelly wanted to go around. Ms. Johnson can tell us.
The Tudor case, number 34 on your list.
All right, that's fine. Yeah, thank you. Calendar number 34. Aimee Baby Tudor, cause number 24701249 to SEA. Council, will you make your appearances for the record in this order? AAG, Mother's Council, Father's Council.
Yes, Sarah Clifton on behalf of the department.
Jill Cagle, DCYF Supervisor.
Alicia Ravinsky, Counsel for the Mother.
And good morning, Your Honor. Kelly Johnson. I'm covering for the Attorney of Record, Maddie Morrison, on behalf of the father. The father is
You're breaking up.
incarcerated and not available to hear. I'm sorry. Kelly Johnson from ACA, covering for Attorney of Record, Maddie Morrison, on behalf of the father.
All right.
And so I think my preliminary issue, if you want me to go first.
I do.
Thank you, Your Honor. Your Honor, the father has already entered an agreed dependency order that was circulated to all parties before an agreed order was submitted to the court. This morning, I think maybe after 8:30 or near 8:30, Father's Counsel became aware that Mother's was ready to enter what was being called an agreed order, but father's counsel had not ever been provided a copy until this morning. We are objecting to language that's in the findings of fact that is about the father. The father is a party to this case. My preliminary request is that this case is continued 2 weeks. I can brief if necessary why father is a party to this case, and an agreed order on this case cannot be entered with findings of fact that are prejudicial to the father. The father has due process rights that are protected under RCW. So we object to this dependency order for the mother being entered on this child. The father is a party. It is incorrect that it is an agreed order at this time. We would like this hearing continued 2 weeks, hoping that reasonable minds can agree with me and that language can get stricken, or I will brief why that language needs to be stricken.
Well, let me indicate this, and then I'll hear from Ms. Clifton and Ms. Ravinsky. Ms. Johnson, as I'm sure you're aware, we enter agreed orders for one parent all the time with the other parent not signing off. I think typically what we do is, in situations such as this, is insert language that makes it very clear that whatever agreed findings there are as to the parent whose order it is do not apply and are not findings as to the other parent.
Well, I mean, I legally disagree with you, Honor, and if it was myself or my office in one of those cases, I will make sure that my staff knows that I do not legally agree with that. It would just like you wouldn't allow a CASA to just not be CC'd on emails. I am sorry that my audio is bad. Can you hear?
All right. I can hear you.
I mean, the language in the order is a sentence only about father. This is not us taking a position on what facts that the mother has personal knowledge about. It's a fact that was stricken in the father's agreed order that was circulated to all parties. I guess we disagree that the father's a party to this case, but this order is presenting a fact that would be a findings of fact that is harmful to the father, and we were not consulted. He has due process to contest that, and if this court is going to be signing an order that has a fact in its findings that is, prejudicial to the father and that he disagrees with, I think that that issue needs to be briefed for the court, for the court to decide why they would enter an order with that language in it.
To be clear, of course, your client is a party. However, I fairly routinely sign orders where it is made clear that the facts in a particular order are only binding and only found as to the parent who's signing the order. But why don't I hear from Ms. Clifton and Ms. Ravinsky?
And to be clear, if the language of the father is stricken, I have no objection to this order, and we would sign that agreed order.
All right. And what I do not want to do is continue this for 2 weeks. So if we have to have some contested hearing about it, I will find a time, even if it's at 5 o'clock this evening. This case has dragged on and on. This is Ms. Ravinsky's last day. I am not going to continue this case. We're going to resolve it today, one way or another. But why don't I hear from you, Ms. Clifton and Ms. Ravinsky, whether either there's a way to strike that one sentence or there's there's language that you would propose that would preclude it from being prejudicial to the father. And do I have a copy of the order? I probably do not. I
can send it to you for reference.
That would be helpful.
Okay, just if you give me one moment, maybe Ms. Ravinsky can go first while I do this.
Well, I mean, at least in email, Ms. Clifton agreed to strike the language. I don't know if you still have that position, at least the court could know that.
Yes, do you want me to send the order now, or do you want me to present argument now? I can't do both at the same time. It will just take me 30 seconds.
You can tell me 3 words that you agree to striking the sentence Ms. Johnson wishes to strike.
Okay, yes, I agree to striking the language that Ms. Johnson requested. We struck that language in the father's order. However, I understand that Ms. Ravinsky's client needs to agree to that before we can enter, because she's already signed the order and she would need, because she indicated she would need to contact her client and get approval for that. However, regarding Ms. Johnson's position that the father needs to agree to the mother's order of dependency in order for us to submit it, I do disagree with that. The father actually he's already submitted his order of dependency. He had an opportunity to negotiate and revise the facts section, which we did. And those are the facts he agreed upon. The mother's order of dependency are the facts that she agrees upon. And that we can submit today. And in order to remedy the situation, another option would be to just add a line into the order that states clearly that the father does not agree to the facts that the mother is agreeing to, if that helps at all. But requiring one parent's agreement on the facts of another parent's agreed order of dependency, I think would set a dangerous precedent, especially in cases involving domestic violence between the two parents, which this happens to fall under that category.
Okay.
Yes, and
Thank
now
you.
I will send the order.
All right. Ms. Ravinsky?
Thank you, Your Honor. Candidly, this is a challenging position, I think, for Ms. Tudor to be in and for me to be in, full candor. I think as the court well knows, today is my last day, so I'm not going to be available even early next week or next week to sort out this matter if it were continued. Ms. Tudor is not present. She's not here on Zoom link right now. She and I understood that we had an agreement with the department. There was a pass it calendar call. And as far as I know, she believed that this order was going to be handed up. She signed a waiver, was prepared to hand it up without a hearing this morning. We negotiated in good faith with the department, and this was part of the proposal that we received from them. We were not involved in early negotiations with respect to the father, so there would be no way to know candidly that that would be something that would be an issue. I just am compelled to respond to Ms. Johnson that we were not notified of the father's agreed order that he entered last Friday either until after 9 o'clock, after the calendar had already begun. And the Father's Council did not ask to be part of the negotiations between the mother and the department, such that we would have been on notice that there would be any issue with respect to entering the agreed order today. I am not in a position to agree to strike agreed facts and to strike facts in an order that Ms. Tudor has already signed. I can't do that for her today. I would also have concerns about handing this off to another attorney at this stage. And I think the court can make a very clear order on the record that the facts contained within the agreed order relate to Ms. Tudor and are findings of fact as to Ms. Tudor and not as to Mr. Tolliver. And I will also note that Ms. Tudor very much wanted this part of her case to be resolved as soon as possible and was eager to get this order entered today. And so I'd ask that the court do that. I will also note, Your Honor, that I am before Your Honor at 2 p.m. I do have things scheduled today. As it is my last day, I have some commitments this afternoon.
All right. Understood.
Your Honor, just briefly, I would ask that the court strike the sentence that the department is agreeing to and the mother's agreed order. The fact goes nothing to whether dependency is found as to mother, and I think that is the clean way to resolve this. I am baffled ethically by some of the other arguments, but I'm stepping in for counsel, so I don't have.
What's the line what's the line we're talking about, just so that I'm clear?
It's number 2, and it's the last sentence regarding a King County case number from 2020.
And Your Honor, just to be clear, I would object to the court striking language.
I understand. I want to be very clear, Ms. Ravinsky. I'm not going to strike language out of your client's agreed order. What I believe I am going to do, because I really think this is the practice, and if you want to take me up on appeal or bring a motion, you may, Ms. Johnson, but this would be completely unwieldy. We would never have agreed orders of dependency if I followed what you are asking me to do. What I will do, what I am going to do, because I think it's frankly true as a matter anyway, is I will add very specific language to the prefatory part of 2.2, indicating that the following facts establishing dependency to the mother have been agreed upon and are findings as to the mother only. I realize that is a change, but it's a change of frankly, that I think is true anyway. It is not a change of substance, but I'm not going to strike a line.
And Your Honor, under another one that might want to be addressed under 1.2, it says appearance. Because we're submitting an agreed order, I put the following persons agree to entry of this order. Maybe we can put an asterisk next to the alleged father's name to the language that you're adding, just to be clear. Ms. Johnson, would that be sufficient?
Yeah, I mean, circulated and I'll sign it as to form only. I think my objection is on the record.
I think that's correct. And so, Ms. Ravinsky, I guess I'll hear from you about whether you object to the, I'm not striking. I mean, frankly, I think if it's not a conviction in the case, it would have been better to say that was allegedly involved in a mass shooting, but I assume you object to that. Is there a conviction in that case?
I believe so. I need to confirm. I can pull it up just to make sure the cause numbers. He has a pretty extensive criminal history, so.
And, you know, I would object to him being added. I don't know what that has to do with the father's orders. These are 2020 cases before the child was born. I'm not sure why mother needs that allegation in here.
I guess where I disagree with you, Ms. Johnson, is that where there are domestic violence allegations, the entire constellation of facts where an alleged victim may have experienced in their life is relevant to decisions they made and how they behaved. If I'm a domestic violence survivor and I know that my perpetrator has killed 7 other people, and I'm not saying that's what your client did, that's relevant to my fear and my context and my domestic violence. So I disagree that it's potentially completely irrelevant. But I do, my understanding is that these facts are really binding only on the mother and only a basis for the mother's dependency. And Ms. Ravinsky, I guess before I need to really get to another matter, this was not even flagged for hearing at the time we called the calendar. But Ms. Ravinsky, I guess I'll hear from you about whether I'm not going to strike the language. I don't think that would be appropriate. I fairly routinely do things like change the date the court asked about ICWA most recently, or change procedural things. And to my mind, what I'm proposing to add is procedural, it's clarifying. But if you object, I suppose what we can do is just leave the record and have Ms. Johnson indicate that, I mean, frankly, if it's a criminal conviction, it's an undisputed fact anyway. So it's a little perplexing about why we're arguing about it. But if it's not a conviction, that's a different story.
And I did look up that cause number. It is a guilty conviction, assault 3, substantial pain, manslaughter 2, and unlawful firearm possession, all guilty.
All right. Let's be clear. I'm just going to sign the order. Ms. Johnson's objection is noted for the record and should be noted however she wants it to be noted on the order.
Thank you for your time, Your Honor.
Thank you. All right. We're going to now move to the Mejia matter. Do we have everyone we need, or are we still?
Good to go.
Okay. Calendar number 20, which was an add-on, Aimee Isabel Mejia, cause number 21700583. SEA. Counsel, will you make your appearances for the record, please? And actually, before I make your appearances, I'm going to have the interpreter introduce herself.
Yes, Your Honor. Good afternoon. Pablo Sepúlveda, certified court Spanish interpreter, permanently sworn, oath on file. Aquí está el intérprete que se presentó. Están llamando el número de causa de Mejía. Se encuentra Mejía, es el número 217005831. ¿Me escucha? ¿Está escuchando?
Before we have any further Spanish interpretation, I really just want the interpreter to introduce, the other interpreter to introduce herself in English, and then I'm going to learn if the Spanish speaker is on the line.
Good morning, Your Honor. Christina Woltz, Washington State Court certified Spanish interpreter. I'm permanently sworn. My oath is on file at the AOC.
And Mr. Amador Mejia, are you on the line? And I will have one of the interpreters ask that question.
Señor Amador Mejía, ¿se encuentra ahí conectado en la línea? ¿Escucha? ¿Puedo abrir su micrófono? ¿Está ahí, señor Mejía? Señor Amador Mejía, aquí está el intérprete. Le preguntan si está en la línea o en la sala.
Sí, estoy aquí.
Yes, I'm here.
All right. I am going to have everyone opt into simultaneous interpretation. I'm going to have the bailiff.
Is he iPhone?
He is iPhone.
Señor, están preguntando si existe la opción de interpretación simultánea. Espere.
Your Honor, this is Catherine Cameron. Is the court planning to send a link to allow us to opt in? Otherwise,
no, there's not a link. It just let me do this though before actually I even hear this. Are we able to? I'm going to shift gears for a moment. Do we have the parties in Beauchamp so I can consider the motion to withdraw?
Yes, Your Honor.
Espere, señor, que están viendo si están aquí hablando de otro caso. Espere.
Okay. Thank you, sir, Mr. Interpreter. All right. I am going to call calendar number 5 and hearing number 4, Inri Marion, Alana, and Micah Beauchamp. Cause number 237019871, 019863, and 019880. KNT. Counsel, will you make your appearances for the record, please?
Good morning, Your Honor. James Hayes for the department.
Señor Mejía, espere que están llamando otro caso. No va a haber interpretación por ahora.
Mr. Sepulveda, I do not need anything interpreted. Thank you.
Yes, Your Honor. That's exactly what I said to Mr. Mejía.
Okay. All right. Go ahead. Mr. Kim, will you make your appearance or go ahead?
Yes, good afternoon. Decamp for the father.
We have Ms. Cowan.
Jennie Cowan representing the CASA, Chris Estella. The CASA is present on the Zoom. I'm sorry, Your Honor.
This is the Beauchamp matter. It's not Chris Estella.
I'm sorry. I'm handling too many this morning. That the guardian ad litem is Pauline Duke.
All right.
Presence.
Ms. Webb is also on the Zoom, Your Honor.
All right. So what I am addressing is the motion, the father's motion to withdraw. I received and reviewed the motion to withdraw. Mr. Kim, I will note that, and I've noted this not particular to your cases, but I have been seeing cases where the attorney's declaration about how notice was given does not match the paralegals. And this is one of those cases where your declaration says that email notice was sent as well as mail notice. The paralegal's notice says that mail was sent. I don't believe that email notice is legally required, but I do think it's preferred to give clients every possible means of notice. Do you know whether email notice was provided?
Yes, it was. I was copied on an email that my paralegal sent to the client. with all the
Perfect.
attachments.
Great.
Yes.
Thank you. Would you just check with your office? I've asked a number of people, please check in with the paralegals and make sure that they modify their declarations of service to include every way they've provided notice to.
I will, thank you.
Thank you.
As indicated in my pleadings, I did staff the motion with my office prior to filing it. And my office deemed it an appropriate case in which we needed to withdraw.
All right, I'm going to have the other parties indicate whether they're taking a position and waive signature on the withdrawal order.
No position from the department, Your Honor, we waive signature.
No position, waive signature.
All right, I am granting the motion to withdraw. I had a note on the calendar and I'm now wondering if that was wrong. Mr. Hayes, had you indicated a plan to take testimony?
The default and take testimony, Your Honor.
And so there's no, have you filed a motion?
We
for
have,
the
Your
fall for today?
Yes, Your Honor.
Okay, with notice to Mr. Kim.
With Mr. Kim, I noticed, and we also certified mail to Mr. Beauchamp as well.
All right, okay. And so let me just take a look at a couple of things. Shannon, do you know, I mean, it's lunchtime. I don't know that we have anyone available to
No, they
take
have
testimony now. Okay.
Judge McCoy can be available at 1:30. They'll have to get to work, but I think they can.
Mr. Hayes, do you know whether you and your witness, so I am granting the motion to withdraw. So Mr. Kim is now withdrawn. Are the other parties all available to appear for testimony before Judge McCoy at 1:30?
I am, Your Honor. I'll defer to Ms. Webb if she's available at 1:30.
I'm at the court's discretion.
I have the Johnson matter at 1 p.m. before Your Honor. So I hopefully we'd be done by 1:30, or I can try to find a coverage attorney, Your Honor, and then I have the 2 p.m.'s motions to withdraw before you.
All right, let's see if we can't make that work.
And Your Honor, may I be excused?
You may, you're excused. You're no
Thank
longer
you.
on this case.
Yes, of course, thank you.
All right, why don't we try to have you go before Judge McCoy at 1:30. That will be the plan, and Ms. Cowan will just have to, if there's any way you can get alternate coverage, that would be great, but what we will try to do is finish with the Johnson matter so that you can go over to Judge McCoy at 1:30.
Yes, Your Honor.
Well, frankly, if okay. All right. All right, now I'm going to circle back to Mejia with apologies to the interpreters for that aside. And
Bien,
we
ahora van
are,
a escuchar el caso del señor Mejía.
what we are going to do is set up the simultaneous interpretation feature. What that means is that anyone who is here on the Mejia case will need to opt into their appropriate language, either English or Spanish, when you see the globe at the bottom.
Bien, entonces, señora, ahora van a activar la interpretación simultánea. ¿Usted sabe cómo conectarse a la interpretación simultánea?
Sí, sí.
Ok. Le dice entonces que tiene que, cuando vea la opción, todavía no, usted tiene que ponerla en español.
Bien, adelante.
Ready to go for it?
Yes.
Sí, la escucho.
And then either Mr. Sepulveda or Ms. Wools, I'm going to have you give me a hand signal. I see a thumbs up from Mr. Sepulveda that he is in communication with Mr. Mejia. And I trust the interpreters will just, Ms. Wools, are you in the Spanish room? It sounds like she is. All right. I'm going to have the attorneys make their appearances now in this order. AAG, Fathers Council, CASA.
Michael Hemker for the department.
And Megan
Good
Stanley.
morning, Your Honor. Catherine Cameron. Oh, sorry.
Sorry, and Megan Stanley, the assigned supervisor.
Good morning again, Your Honor. Catherine Cameron, and I represent Mr. Mejia. And Mr. Mejia, of course, is here attending via cell phone.
Jennie Cowan representing the CASA, Chris Estella. And the CASA is present.
All right, I understand that I think Ms. Cameron, and I do see that Mr. Estella is present on Zoom. We previously heard from Mr. Mejia, and so now he is present as well. I think Ms. Cameron had initially requested this status conference, and so I will hear from you first.
Thank you, Your Honor. So the reason that we are here today is I've requested a motion on shortened time, and I believe that we have good cause. The issue is that the neuropsychological report was received this past Wednesday, and the state's attorney thankfully passed it on to us. However, Mr. Mejia has two experts that would need time to review the report and prepare for trial. If the trial, of course, as Your Honor knows, is set for September 16th. If the court were not to grant a continuance, which is what we're asking for, that would only allow 16 calendar days, that's excluding Labor Day, for two separate experts to review this report and any relevant discovery and prepare for trial. If we only have 16 days, then that puts Mr. Mejia at considerable disadvantage and would prejudice his rights, I believe, if the court were to allow the trial to go ahead on September 16th. As Mr. Mejia's counsel, I am well aware that this is a hard set trial. However, under the circumstances, I believe that the court would have good cause to continue the trial.
All right, let me ask a couple of things, and then I will hear from the other parties. Is there an agreement to me hearing what? I don't have a written motion for an order shortening time, do I at this point?
Your Honor, I did file one last night. This is kind of a very short notice, so I did file one.
I just need to know what you filed or didn't file. You filed a motion for order shortening time last night. Is that right?
That's correct.
All right. I'm just going to ask the other parties, do they agree that this motion can be heard on shortened time?
Yes, Your Honor.
Yes.
All right. Then I do grant shortened time to hear this request for continuance. And then I'm going to pose a couple of other questions. I'm interested in knowing how long the report is and what it recommends. And then I am also interested in having all counsel respond to the idea of having trial move forward, but potentially having the date for Ms. Cameron's experts, leaving an extra day that is later for Ms. Cameron's experts. That strikes me as one option that involves less delay. So finding some other day that would, or half day, however long we think Ms. Cameron's experts would take. Although appreciating that that means you then go through the first part of trial, not necessarily knowing what her experts have to say. So those are the questions I have running through my mind, and I guess I will hear the departments and CASA's positions on the continuance. And I also wonder whether any notice was given to the caregiver of today's hearing.
Your Honor, I was not able to give notice to the caregivers. As Father's Counsel, I don't have any direct contact information, and probably that is something that I did not consider when I, in the limited time that I had.
So my question,
and
and I really, it's 12:17, so I need people to kind of be as brief as they can be when I have a question. And perhaps the department has notified the caregiver.
Your Honor, I don't know if the caregivers have been notified. I don't believe that they have.
All right.
To try to answer the court's questions, the report is, I believe, 37 pages long. It ultimately recommends that reunification is not appropriate. It comes to the conclusion that Mr. Mejia does not have an intellectual disability. However, there is testing parameters that would indicate that he does, but the evaluator gives reasons as to why those results would not be correct. So that's the basic gist of the report. It also recommends that Isabella go under a forensic evaluation relating to changed memories or being influenced. Those are the main conclusions that were outlined. The dates that Ms. Cameron posed before we came onto the calendar was either October 1st or October 7th for continuance. So it's not a lengthy request if that's the dates she's sticking with. I am unavailable that weekend leading up to the 1st, so I would personally request the 7th if we were going to continue it. I've spoken with my client and they are okay if that was the date that the court is inclined to continue it till. I appreciate the court giving this alternative of what could occur, but being the party that has the burden of proof, I would prefer to know what the defense is going to present and be able to be prepared for that in presenting my case to counteract that and not be surprised.
All right. Why don't I hear from CASA?
Your Honor, I'm just covering this for Ms. Rivera. I think that I have, that my client has had the chance to review the neuropsych from the department. And I would agree with Mr. Hemker that if he's the petitioner and has the burden of proof, he needs the time. And I don't think October 7th is too far off from where we were, although the CASA reluctantly, recognizes that we need to continue.
All right. I think, so here's my question is, it appears that it makes sense to me. This is a significant report. It was just received. You all seem to be in agreement and the requested continuance is relatively short. Does October 7th remain a date available to you, Ms. Cameron?
Yes, Your Honor.
And so here's my question, because it looks like in terms of the court's availability to hard set at this point in time, I think it would end up being set back to me because Judge Chung is not available and I suddenly am. And so we would set it to me on October 7th, 8th, and 9th. And 15th and 16th. Would you remind me, is it currently, I think it's a 5-day trial, is that right?
I would have to pull up the PTC order, but that does sound accurate. It's either 5 or 5.5 days, but
And Your Honor, I'm sorry, I'm looking at Ms. Rivera's leave. It looks like she's on leave from September 30th to October 11th.
All right. What about October 15th, 16th, and 21st, 22nd, and 23rd?
So, Your Honor, one of my experts, Dr. Judd, is not going to be available. He will be unavailable from October 10th through November 10th.
So were you going to have to take him out of order probably?
That would be correct, Your Honor.
And is he not even available remotely during that period of time?
I have not asked him, that was not a question that occurred to me in a limited time. Well, I don't know, Your Honor. I didn't ask him that question specifically.
This is a case that Ms. Rivera has been involved with for a long time. It seems unlikely to me that she can simply have coverage. And the problem is that, and Ms. Cowan, Ms. Rivera is out until when, the 11th?
Yes, I'm just trying to text her right now, but she's, in Asia right now, so I don't know. But it says September 30th to October 11th. That's what's on the calendar for the court.
All right, I really have one other matter I still need to address on this calendar. I would have granted a continuance until October 7th, but that doesn't appear to me to be a possible date. And it sounds like we are missing information about when is a possible date. We're missing information from Ms. Cameron about, sounds like her expert is just sort of unavailable for a large chunk of time. And we don't have any sense of whether there's any possibility. So I guess I think you're not really offering me the dates you said you were. And I don't think we have full information about where that means we would end up.
So, Your Honor,
we would be well into November, when in fact there are no hard set dates available with the court.
So, Your Honor, would the court be willing to allow parties to come back on the 13th? I just heard that Ms. Rivera returns on the 11th. So if we came back on the 13th and she had the opportunity to review her calendar, that might be helpful in terms of setting this trial.
Well, the longer we have go by, and Ms. Cowan, do you have any sense? Ms. Rivera is gone from now until when?
She'll be back on Monday, the 9th, I believe, of September to answer this question.
Okay.
All right, here's what I'm going to order. I'm going to order that the parties, subject to hearing something from Ms. Rivera, hold available the 7th through 9th and 15th and 16th and 21st through 23rd of October. We are going to tentatively hold those case dates on my calendar. It really sounds like between Ms. Cameron's expert and Ms. Rivera that those dates do not work. But what I need to hear, Ms. Cameron, I need you to press your expert about whether there's any way they can appear remotely for half a day during the time frame they're gone if we accommodate their schedule. And I need to hear from Ms. Rivera whether there's any flex in her schedule and or any ability to have the matter be covered, which I'm assuming the answer to that is no, but I know that she and her client are also interested in having this move forward, and I fear that it will not if we don't get it out on those dates in October. I am going to set a hearing at 8:30 a.m. on Monday, September 9th. A further status conference in this matter. I think we already have it set then. All right, any other, Ms. Stampley, go ahead.
I'm sorry, are we also holding the current dates or are we not moving forward?
We are not holding the current dates. It really appears to me that everyone agrees that that is not viable. Is that a fair assessment?
Yes, I think unfortunately, reluctantly, we're agreeing just because of the nature of the defense request.
All right, and so that means we'll be able to free up that time for Judge Chung and others. All right, I really need to move on to my last matter on the calendar for today. Is there anything else you think we need to address today? Is there anyone who cannot be present at 8:30 on September 9th? And are there any questions about, so really the order should reflect that the September 16th trial date before Judge Chung is stricken, that there's a status conference on September 9th at 8:30 a.m., and that the parties will hold, to the extent they do not already have a conflict, October 7th through 9th, 15th and 16th, and 21st through 23rd. That Ms. Cameron is to check with Dr. Judd about any availability. And Ms. Cameron, I'm going to need to have an understanding of why there are two separate experts. And if Dr. Judd can't make himself available for that entire period that he's blocked out, I'll need an understanding of why. And to be clear, I'm not doubting that necessarily he's necessary. I just don't know what the role is of each expert.
Would you like that clarification now or on the 9th?
No, I'm going to want it on the 9th. I'm just giving you a heads up about that. I won't need clarification if it turns out Dr. Judd can make themselves available sometime during that block of time.
Your Honor, I know you're short on time, but unless I'm missing something, I've only received the name of one expert for Ms. Cameron, so the second expert is a surprise to me.
Ms. Cameron, have you disclosed a second expert?
This is the expert that I've disclosed before, which would be Dr. Antunia.
Oh, okay.
Okay, I'm going to let you address all of that offline. I would actually also like someone to provide me with a copy of the report. And perhaps that means it should be filed, because I think a lot of what I'm going to be having to address is different contention. So maybe if someone's filing a motion or something, they could attach it to that. I don't know that we necessarily need a motion. We're going to be considering trial setting on September 9th. I think it's relevant for me to see that report to have an understanding of what's involved. So can the department file that?
Yes, that can be filed with a cover sheet to the court if that's appropriate.
That would be fine. If you would send us a working copy as well, that would be great.
Your
Okay.
Honor, one more item that is relevant, and I have not reviewed it yet, but the department did file some additional discovery on August 28th as well. And
All right.
I just wanted that noted for the record.
All right. All right, so I will receive that order before the end of the day today. I believe that now concludes our calendar, except for the Zayas matter, which we are going to be handling in person only. And so we will be logging off of the Zoom. Is there anyone else? And so the interpreters are both excused. Thank you very much for your help. Is there anyone else on the line who believes there's a matter that hasn't been heard other than Zayas? All right, that will conclude the Zoom portion of the calendar.